I was staring at the eviction notice taped to my front door when I realized the Pinewood Heights Homeowners Association had finally lost their minds. The paper flapped in the cold February wind, and I could see my neighbor across the street peering through her curtains, probably wondering what drama was unfolding now. According to this official-looking document, I had 72 hours to vacate my property in Boulder, Colorado, because of unauthorized mechanical equipment use, specifically my snowblower. The same snowblower I'd been using for 3 winters without a single complaint until Patricia Morrison became the HOA president 6 months ago. My name is Lucas Yates, and I'd lived in this quiet suburban neighborhood for 5 years. I'm a software engineer who works from home, which means I'm around to witness all the ridiculous HOA nonsense that goes down during business hours. When I first bought my house, the HOA seemed reasonable enough. They kept the common areas maintained, organized a few neighborhood events, and generally stayed out of everyone's way. Then, Patricia took over and suddenly everything became a problem. My grass was a 1/4 inch too tall. My mailbox needed repainting. My Christmas lights were the wrong shade of white. But this eviction notice over a snowblower crossed a line I couldn't ignore. I ripped the notice off my door and went inside, immediately calling my friend Derek, who happened to be a real estate attorney. He didn't specialize in HOA law, but he knew enough to point me in the right direction. The phone rang 4 times before he picked up. "Lucas, what's going on?" Derek asked, his voice slightly muffled like he was eating something. "The HOA just served me an eviction notice. They're trying to kick me out of my house because I used my snowblower," I said, pacing around my living room. "Can they even do that?" Derek was silent for a moment, then I heard him swallow. "Wait, what? An eviction notice from an HOA? That doesn't sound right at all." HOAs can file liens or take you to court over violations, but they can't just evict you. You own the property, right? You're not renting. I own it outright. Paid off the mortgage last year, I confirmed, feeling slightly less panicked. "So this is bogus. Send me a photo of the notice." "I want to see the exact wording," Derek said. I could hear him moving around, probably heading to his computer. "But off the top of my head, this sounds like a massive overreach of authority. HOAs have covenants, conditions, and restrictions they enforce. But eviction isn't one of their powers unless there are very specific circumstances that definitely don't include snowblower usage." I took a photo of the notice and sent it to Derek, then read through it more carefully while I waited for his response. The document cited Section 12.7 of the HOA bylaws, which apparently prohibited the use of gas-powered lawn equipment during certain hours. My snowblower was gas-powered, sure, but the bylaw specifically mentioned lawn equipment. Last time I checked, snow wasn't lawn. "This is insane," Derek said when he called me back 5 minutes later. "First of all, the bylaw they're citing is about lawn equipment, not snow removal equipment. Second, even if you violated the bylaw, the penalty structure outlined in your HOA documents, which I just pulled up online because your neighborhood's CC and Articus are public record, starts with a warning letter, then escalating fines, and eventually a lien. Nowhere does it say they can evict you. This Patricia person is either completely incompetent or deliberately abusing her position." "What should I do?" I asked, already knowing I wasn't going to let this slide. "Document everything. Take photos, keep all correspondence, and don't leave your house based on this fake eviction notice. I'll refer you to someone who specializes in HOA disputes. Her name is Amanda Fletcher, and she's tough as nails. If Patricia Morrison wants a fight, Amanda will give her one," Derek said with satisfaction in his voice. He'd clearly dealt with overzealous HOAs before and enjoyed seeing them get knocked down a peg. I called Amanda Fletcher's office that afternoon and somehow got an appointment for the next morning. Her receptionist mentioned there'd been a cancellation, which felt like fate intervening on my behalf. That evening, I went through every piece of documentation related to my house purchase, including the full HOA bylaws, the CC and Articles, and all the correspondence I'd received from the HOA over the years. Most of it was routine stuff, but the letters from the past 6 months after Patricia took over showed a clear pattern of harassment. She'd sent me violation notices for things that weren't actually violations, like parking my truck in my own driveway overnight or having a wreath on my door past January 15th. The next morning, I drove to Amanda Fletcher's office in downtown Boulder. Her office was in a modern building with floor-to-ceiling windows that overlooked the Flatirons. The receptionist, a young guy with glasses and a friendly smile, offered me coffee while I waited. Amanda came out to greet me herself 5 minutes later. She was probably in her early 40s, with dark hair pulled back in a professional bun and sharp brown eyes that seemed to assess everything in an instant. "Lucas Yates?" she asked, extending her hand. Her handshake was firm and confident. "Come on back. Derek told me a little about your situation, and I have to say, it's one of the more egregious cases I've heard in a while." Her office was organized and efficient, with law books lining one wall and framed degrees from the University of Colorado on another. She gestured for me to sit in a comfortable leather chair across from her desk, then sat down and pulled out a legal pad. "Walk me through everything, starting from when you first noticed problems with the HOA," Amanda said, pen poised and ready. I spent the next hour detailing every interaction I'd had with Patricia Morrison and the HOA board. Amanda took notes, occasionally asking clarifying questions. When I got to the part about the eviction notice, her eyebrows rose slightly, but she didn't interrupt. After I finished, she sat back in her chair and tapped her pen against her lips thoughtfully. "Okay, here's what we're dealing with," Amanda began. "Patricia Morrison has committed several violations of Colorado HOA law. First, the eviction notice has no legal standing whatsoever. HOAs cannot evict homeowners from properties they own. They can foreclose after placing a lien, but that's a lengthy legal process with many requirements. She can't just decide you have 72 hours to vacate. Second, even if your snowblower use violated the bylaws, which it doesn't because the bylaw concerns lawn equipment and snow removal isn't lawn maintenance, she didn't follow the proper penalty procedures. You're supposed to receive a warning first, then escalating fines if violations continue. Third, and this is the kicker, I pulled up your HOA's registered documents yesterday after Derek called. Patricia Morrison isn't actually the legitimate HOA president." I stared at her. "What do you mean?" "The HOA board election that supposedly put her in charge happened at a meeting where quorum wasn't met. According to your bylaws, you need at least 60% of homeowners present or represented by proxy for a valid board election. Only 43% of homeowners were present at that meeting. I found the meeting minutes online because HOAs are required to post them. The election was invalid from the start, which means every action she's taken as president has no legal authority," Amanda explained, and I could see the hint of a smile playing at the corners of her mouth. She was enjoying this. "So what happens now?" I asked, feeling vindicated but also slightly overwhelmed by the implications. "Now we go on the offensive. We're going to file a lawsuit against Patricia Morrison personally and the HOA board for harassment, abuse of authority, and violating Colorado's HOA regulations. We'll also request an injunction to prevent them from taking any further action against you, and we'll ask the court to declare all of Patricia's actions as precedent void. When HOAs overstep this badly, courts don't mess around. They take it seriously because homeowners need protection from exactly this kind of abuse, Amanda said, already making notes about our legal strategy. Over the next 2 weeks, Amanda worked fast. She filed our lawsuit in Boulder County District Court and requested an emergency hearing for the injunction. The HOA's attorney, a bored-looking guy named Richard something who'd probably handled 100 routine HOA cases, seemed completely unprepared for the level of documentation and legal precision Amanda brought to the table. At the emergency hearing, Amanda presented evidence of the invalid election, the improper eviction notice, and the pattern of harassment. The judge, a stern woman named Judge Catherine Reynolds, who had a reputation for not tolerating nonsense, granted our injunction immediately and scheduled a full hearing for 3 weeks later. The court finds sufficient evidence that the plaintiff may suffer irreparable harm if the HOA is allowed to continue its current course of action, Judge Reynolds said, looking over her glasses at the HOA's attorney. The defendant HOA is hereby enjoined from taking any enforcement action against Mr. Yates pending the resolution of this case. Furthermore, I'm ordering the HOA to post notice of this injunction in all common areas and to send written notification to all homeowners that the recent board election's validity is under legal challenge. The HOA's attorney, Richard Donovan, I'd learned his name by then, tried to argue that the injunction was too broad, but Judge Reynolds shut him down quickly. Counselor, your client attempted to evict a homeowner using a fabricated legal authority. The injunction stands as written. Walking out of that courthouse felt incredible. Amanda was already planning our next steps, talking about depositions and discovery requests, but I was just savoring the moment. For the first time since Patricia Morrison had taken over the HOA, I felt like I had some power back. That satisfaction lasted until I got home and found Patricia Morrison standing in my driveway with 2 other HOA board members, Gerald Hoffman and Susan Chen. Patricia was exactly what you'd picture when someone says, HOA Karen in her mid-50s, with blonde highlighted hair styled in that specific suburban mom cut, wearing yoga pants and an expensive parka despite probably not having exercised in years. Her face was already red with anger before I even got out of my truck. You think you're clever, don't you? Patricia snapped as I approached. Suing the HOA because you can't follow simple rules. Patricia, you were served with a court order today. You're not supposed to be contacting me about HOA business, I said calmly, pulling out my phone to record the interaction. Amanda had told me to document everything. I can stand in a public driveway if I want, Patricia shot back, though her eyes flicked nervously to my phone. Gerald, a retired accountant who usually kept quiet during HOA meetings, looked uncomfortable, shifting his weight from foot to foot. Susan, who ran a local boutique, at least had the decency to look embarrassed. This isn't a public driveway. It's my private property and you're trespassing. I'm asking you to leave, I said, keeping my voice level despite wanting to tell Patricia exactly what I thought of her and her fake authority. We just wanted to talk reasonably, Susan interjected, her voice softer than Patricia's aggressive tone. Maybe we can settle this without all the legal drama. It's costing the HOA a lot of money in attorney fees. You should have thought about that before trying to evict me illegally, I replied. I'm not settling anything. Your president here has been harassing me for months, and the court's going to hear about all of it. Now please leave before I call the police for trespassing." Patricia's face somehow got even redder. "You're destroying this neighborhood. Do you know how much property values could drop if word gets out that homeowners can just ignore HOA rules?" "I didn't ignore any rules. I used a snowblower to clear my driveway. That's not a violation of anything except Patricia's weird power trip," I said, done with trying to be diplomatic. "Leave? Now." Gerald finally spoke up, his voice quiet. "Come on, Patricia, we should go. The lawyer said not to contact him directly." Patricia looked like she wanted to argue more, but Gerald was already walking back toward the street where they'd parked. Susan followed, leaving Patricia standing alone in my driveway. She gave me one last furious look before spinning on her heel and stalking away. I watched them drive off, then immediately sent the video to Amanda with a text explaining what had happened. She called me within minutes. "That was incredibly stupid of them. Violating a court order like that gives us even more ammunition. I'm going to file a motion to hold Patricia in contempt. Keep recording any contact they make with you." The weeks leading up to the full court hearing were tense. Patricia apparently didn't learn her lesson because she sent a mass email to all HOA members painting me as a troublemaker who was costing everyone money with frivolous lawsuits. Amanda added that to our evidence pile as further harassment. A few of my neighbors reached out privately to express support. My next-door neighbor, an elderly man named Tom who'd lived in the neighborhood since the houses were built, came over one evening with copies of old HOA documents. "I saved these from when the HOA was first established," Tom said, handing me a folder full of papers. "Patricia tried to change a bunch of the bylaws without proper procedure about a month after she took over. I objected at the time, but she said as president she had the authority. These show what the original bylaws actually said." I invited Tom in for coffee and looked through the documents. He was right. Patricia had sent out revised bylaws that included much stricter rules and harsher penalties. But according to the original HOA governing documents, any changes to the bylaws required a vote of all homeowners with a 75% approval threshold. Patricia had just decided to change them on her own authority. "Tom, this is huge. Can I give these to my attorney?" I asked, carefully looking through each page. Some of the changes Patricia had made were significant. She'd lowered the threshold for violation fines, expanded what counted as violations, and given herself broader powers to enforce rules. That's why I brought them over. Patricia's been a menace since day one. Most of us were too tired or busy to fight her, but I'm glad someone finally is," Tom said, warming his hands on his coffee mug. "She sent me a violation notice last month because my porch light was supposedly too bright. I've had the same light for 20 years, and it's never been a problem before." I spent that evening scanning all of Tom's documents and sending them to Amanda. Her response came through at nearly midnight. "This is perfect. She's not just overstepping her authority, she's been operating under completely unauthorized rules. We're going to destroy their case." The full court hearing was scheduled for a Tuesday morning in late March. Spring was just starting to show in Boulder, with patches of snow still clinging to shaded areas, but crocuses pushing up through the soil in sunnier spots. I wore my best suit and met Amanda outside the courthouse at 8:30. She was already there, reviewing notes and looking confident in a sharp navy pantsuit. "Ready?" she asked, snapping her folder shut. "As ready as I'll ever be," I replied, straightening my tie nervously. The courtroom was one of the smaller ones in the courthouse, with wooden benches and that particular smell of old furniture, polish, and tension that seemed universal to legal proceedings. Patricia was there with the other board members and their attorney, Richard Donovan, who looked significantly more stressed than he had at the emergency hearing. Apparently, he'd done his homework this time and realized how badly his clients had messed up. Judge Reynolds entered, and we all stood. She took her seat, arranged her papers, and looked directly at the HOA's side of the courtroom. Before we begin, I want to address the contempt motion filed by Mr. Yates' attorney. Mrs. Morrison, did you approach Mr. Yates at his home after being served with a court order specifically prohibiting such contact? Patricia stood up, and I could see her hands trembling slightly. Your Honor, I was just trying to resolve the matter amicably. I didn't think standing in his driveway counted as official HOA business. You didn't think, Judge Reynolds repeated, her tone making it clear what she thought of that excuse. Mrs. Morrison, court orders aren't suggestions. They're legally binding directives. Your attorney is present, which means you have legal counsel who should have explained this to you. I'm finding you in contempt and fining you personally $1,000. If there are any further violations of court orders in this case, I'll consider jail time. Am I clear? Yes, Your Honor, Patricia said weakly, sitting back down. I saw Susan Chen close her eyes and shake her head slightly. Even from across the courtroom, I could tell the board members were beginning to realize they'd backed the wrong person. The hearing proceeded from there. Amanda presented our case methodically, walking through each piece of evidence. She showed the invalid board election results, explained how Patricia had failed to follow proper penalty procedures, demonstrated that my snowblower use didn't violate any actual HOA rules, and then dropped the bomb about Patricia's unauthorized bylaw changes. Richard Donovan tried to mount a defense, but it was clear he was working with a losing hand. Your Honor, the HOA board acted in what they believed was the best interest of the community, Richard argued weakly. While there may have been some procedural irregularities, there was no malicious intent. Procedural irregularities. Judge Reynolds looked at him incredulously. Counselor, your client attempted to evict a homeowner without any legal authority to do so. That goes far beyond a procedural irregularity. This court takes property rights very seriously, and HOAs do not have unlimited power to harass homeowners. Amanda stood to give her closing argument. Your Honor, this case represents exactly the kind of HOA abuse that Colorado law is designed to prevent. Mr. Yates did nothing wrong. He used a snowblower on his own property to clear his driveway, which is not only reasonable but necessary in a Colorado winter. Instead of being left alone to enjoy his property, he was subjected to months of harassment culminating in a completely fabricated eviction notice. The HOA board, under Mrs. Morrison's leadership, has operated without proper authority, changed bylaws without homeowner approval, and attempted to enforce rules that don't exist. We're asking the court to rule that the HOA had no authority to take any action against Mr. Yates, to void all penalties and notices issued to him, and to impose sanctions on the HOA for their abusive behavior. Judge Reynolds took a brief recess to review all the evidence, and those 20 minutes felt like hours. Amanda seemed calm, reviewing her notes and occasionally jotting something down. I tried to look equally composed, but mostly just felt anxious. Finally, the bailiff called us back into the courtroom. I've reviewed all the evidence and arguments presented today, Judge Reynolds began, and the courtroom went completely silent. The court finds in favor of the plaintiff, Lucas Yates, on all counts. The HOA board election that placed Patricia Morrison in the position of president was invalid due to failure to meet quorum requirements. As such, every action taken by Mrs. Morrison as president had no legal authority. The eviction notice served to Mr. Yates is void and unenforceable. The court further finds that the HOA violated Colorado Revised Statutes Section 38-33.3 regarding HOA governance and homeowner rights. Patricia had gone pale, and Gerald was staring at the table in front of him. Susan looked like she might cry. Richard Donovan was taking notes frantically. Judge Reynolds continued. The court orders the following. First, all penalties, fines, and violation notices issued to Mr. Yates are void and unenforceable. Second, the HOA must hold a new board election following proper procedures within 60 days. Third, the HOA is prohibited from taking any enforcement action against Mr. Yates regarding his snowblower or any other matter, unless clear violations of properly enacted bylaws occur and proper penalty procedures are followed. Fourth, the HOA is ordered to pay Mr. Yates attorney fees and court costs. Fifth, the court is imposing a sanctioned fine of $15,000 on the Pinewood Heights HOA for abuse of authority and harassment. This fine shall be paid within 90 days. The gavel came down with a sharp crack that seemed to echo through the courtroom. Amanda leaned over and whispered, "That's a complete victory. The fine is particularly significant because it sends a message to other HOAs." As we filed out of the courtroom, I saw Patricia arguing with Richard Donovan in harsh whispers. The other board members were keeping their distance from her. In the hallway, Tom was waiting. He'd shown up to watch the proceedings, and his face lit up when he saw my expression. "We won," he asked hopefully. "Complete victory. The HOA has to pay my attorney fees and got hit with a $15,000 fine," I said, still processing it all. "And Patricia's actions as president were declared invalid." Tom actually laughed out loud. "That's the best news I've heard in months." "Wait until I tell the other neighbors. There are at least a dozen people she's harassed who will be thrilled." Over the next few days, word spread through the neighborhood fast. I received more than 20 emails and several visits from neighbors thanking me for standing up to Patricia. Apparently, she'd been terrorizing multiple people with bogus violation notices. One couple had been threatened with fines because their mailbox was slightly faded. Another neighbor had been cited for having decorative rocks in their garden that Patricia claimed violated the landscaping rules. Except the landscaping rules didn't mention decorative rocks at all. The fallout for Patricia was swift and severe. At the emergency HOA meeting called to address the court ruling, which I attended along with about 60 other homeowners in a neighborhood of 75 homes, the mood was openly hostile toward her. She tried to maintain that she'd been acting in everyone's best interests, but people weren't buying it anymore. "You cost our HOA $15,000 because of your power trip," one homeowner shouted during the open comment period. "That money comes out of our HOA fees, which means you've essentially stolen from all of us." "I was trying to maintain property values," Patricia protested weakly from her position at the front table. "If we don't enforce rules, the neighborhood goes downhill." "You weren't enforcing rules. You were making up rules and harassing people," another neighbor called out. "I got a violation notice for having my trash cans visible from the street, but there's no bylaw about trash can visibility. You just didn't like where I put them." Tom stood up, and the room quieted down to hear him speak. "Patricia, you've been a disaster as HOA president, and frankly, I use that title loosely since the court determined your election was invalid. I'm calling for an immediate vote of no confidence. Everyone in favor of removing Patricia Morrison from any position of authority in this HOA, raise your hand." Every single hand in the room went up except Patricia's and her friend Barbara, who had supported her power-hungry crusade. Even Gerald and Susan, the other board members, raised their hands. Patricia looked around the room, her face cycling through anger, shock, and finally resignation. She grabbed her papers and purse and walked out of the meeting without another word. I never saw her at another HOA function again. The next few weeks were busy with restructuring the HOA properly. A nominating committee was formed to find board candidates who would actually serve the community instead of wielding authority like a weapon. Tom ended up running for president and won easily. The new board's first action was to review all the bylaw changes Patricia had implemented and reverse them, returning to the original, more reasonable rules. They also established a formal appeal process for violation notices, so homeowners had recourse if they received citations they believed were unfair. In early May, I received a check from the HOA covering all my attorney fees and court costs. Amanda had done her final billing, and the total came to just over $22,000, which I felt was worth every penny for the principle of the matter. Along with the check was a letter from Tom in his new role as HOA president, formally apologizing for the harassment I'd endured and thanking me for standing up to corruption. One Saturday morning, I was outside washing my truck when Susan Chen walked over. She looked nervous, fidgeting with the leash of her small terrier who was sniffing around my front yard. "Lucas, do you have a minute?" she asked hesitantly. "Sure, what's up?" I turned off the hose and dried my hands on a rag. I wanted to apologize personally for everything that happened. I knew Patricia was going too far, but I was too much of a coward to stand up to her. When she started talking about the eviction notice, I should have objected, but I just went along with it. "I'm sorry," Susan said, and she genuinely looked remorseful. "I appreciate that. For what it's worth, I could tell you weren't comfortable with how things were going," I said. The truth was that Susan had seemed more like someone who got swept up in Patricia's wake rather than an active participant in the harassment. I resigned from the board after the vote of no confidence. "I'm not cut out for HOA politics, apparently," Susan said with a rueful smile. "But I'm glad you fought back. Patricia needed to be stopped, and none of the rest of us had the backbone to do it." We chatted for a few more minutes before Susan headed back to her house. It was one of several apologies I received over the following weeks from people who felt they should have spoken up sooner. I didn't hold grudges. Patricia had been the real problem, and she was gone now. The neighborhood felt different already, more relaxed, like everyone could finally breathe. The next winter, I used my snowblower freely whenever it snowed, which in Boulder meant fairly regularly from November through March. Nobody said a word about it. In fact, after a particularly heavy snowfall in January, Tom asked if I'd help clear the sidewalks in the common areas with my snowblower since the HOA's contract company was running behind. I was happy to help, and it felt good to use the machine that had started this whole mess for something positive and community-oriented. Patricia and her husband ended up selling their house that spring and moving to Arizona. I heard through the neighborhood grapevine that she joined an HOA board there within a month of arriving, which made me feel sorry for her new neighbors. Some people never learn. Her house sold quickly to a young couple with a toddler who were friendly and normal and just wanted a nice place to raise their kid. They had no interest in HOA drama, which made them perfect neighbors as far as I was concerned. The lawsuit and its outcome actually became somewhat famous in local HOA circles. Amanda told me she'd been contacted by at least 5 other homeowners dealing with overzealous HOAs who wanted to know if she could help them too. The Boulder Daily Camera ran a story about the case under the headline, "Homeowner Wins Big Against HOA Overreach." and I got interviewed about the importance of knowing your rights and not being intimidated by HOA boards that exceeded their authority. A lot of people don't realize that HOAs have limited powers, I told the reporter, a young woman named Jennifer who seemed genuinely interested in the issue. They can enforce rules that are clearly spelled out in the bylaws, but they can't just make things up as they go along. And they definitely can't evict you from a property you own. If I just accepted that eviction notice without consulting an attorney, I might have voluntarily left my home based on a complete lie. The article ran with a photo of me standing in front of my house, holding my snowblower. Amanda thought it was perfect. Nothing like a little public embarrassment to make HOAs think twice before pulling this kind of stunt, she said when she saw the article. Tom turned out to be an excellent HOA president. He operated with transparency, sent out detailed financial reports quarterly, and actually asked homeowners what they wanted from their HOA instead of just imposing his vision. Under his leadership, the neighborhood got new playground equipment for the common area park, organized a successful 4th of July block party, and established a neighborhood watch program that made everyone feel safer. The difference between his leadership and Patricia's reign of terror was like night and day. About a year after the court case concluded, I was elected to the HOA board myself. I'd resisted at first, having had my fill of HOA drama, but Tom convinced me that my experience made me valuable in preventing future abuses. My role focused mainly on reviewing violation notices before they were sent out to ensure they were legitimate and proportional. It was amazing how many proposed citations I had to veto because they were based on personal preferences rather than actual bylaws. We'd become so conditioned to Patricia's arbitrary enforcement that some people thought that was normal HOA behavior. During one board meeting, Gerald proposed sending a violation notice to a homeowner who'd painted their front door a dark teal color. It's not in keeping with the neighborhood aesthetic, Gerald argued. I pulled out the bylaws and flipped to the section on exterior modifications. There's nothing in here about door colors. We can't enforce rules that don't exist. If the community wants to establish door color restrictions, we'd need to propose a bylaw amendment and get it approved by 75% of homeowners. Otherwise, people can paint their doors whatever color they want. Gerald grumbled but acknowledged I was right. That became my role on the board, the person who made sure we stayed within our actual authority. It was less exciting than the lawsuit, but it was important work that protected homeowners from the kind of harassment I'd endured. The $15,000 fine that Judge Reynolds had imposed on the HOA ended up being paid through a special assessment rather than raising everyone's regular HOA fees. Tom felt it was important that homeowners understood why they were being charged extra. He sent out a detailed letter explaining the entire situation, how Patricia's actions had led to the lawsuit, and why the fine was levied. While nobody was happy about the additional expense, most people understood it was necessary accountability for what had happened. A few homeowners, mainly Patricia's friends, grumbled that I should have just settled quietly, but they were in the minority. That special assessment ended up having an unexpected benefit. Because homeowners had to pay extra due to Patricia's misconduct, they became much more engaged with HOA governance. Attendance at board meetings shot up from the usual 10 or 15 people to 40 or 50. People paid attention to what the board was doing and weren't shy about speaking up if something seemed wrong. It created exactly the kind of accountability that prevents HOA abuse in the first place. Derek, my attorney friend who'd initially pointed me toward Amanda, came over for a barbecue that summer. We sat on my back deck, beers in hand, watching the sun set over the flatirons while burgers cooked on the grill. "You know, when you first called me about that eviction notice, I thought it would be a straightforward case of HOA overreach," Derek said, taking a sip of his beer. "I didn't expect it to turn into this whole thing with invalid elections and major sanctions." "Neither did I admitted. "I just wanted them to leave me alone about my snowblower." The rest of it unfolded as Amanda dug deeper into the HOA's records. "Amanda's good. She's represented a few clients my firm has referred over the years, and she doesn't mess around with bad HOAs," Derek said. "But you made the right call fighting it. A lot of people would have just moved rather than dealing with the legal battle." That's what Patricia was counting on. She figured she could bully people into compliance or drive them out of the neighborhood if they resisted. It worked on some people, too. "The Hendersons on Maple Street sold their house specifically because Patricia made their lives miserable," I said, flipping the burgers. The smell of grilling meat mixed with the scent of pine trees from the nearby foothills. "Well, you did the neighborhood a service. And probably set legal precedent that'll help other homeowners dealing with similar situations," Derek pointed out. "Judge Reynolds' ruling was pretty comprehensive. It'll get cited in other HOA cases." That thought made me feel good about the whole ordeal. Yeah, it had been stressful and time-consuming, and I'd spent months feeling angry and frustrated, but ultimately something positive had come from it. The neighborhood was better off. Other homeowners had been emboldened to stand up for their rights, and Patricia's reign of terror had been definitively ended by a court ruling that made clear HOAs couldn't just do whatever they wanted. I kept all the legal documents from the case in a folder in my home office. Every now and then, someone from the neighborhood would ask to see them, usually because they were dealing with an HOA issue themselves or knew someone who was. I was always happy to share my experience and explain what I'd learned about HOA law. Knowledge was power, and the more homeowners understood their rights, the less likely they were to be victimized by power-hungry board members. The snowblower itself, the humble machine that had sparked this entire legal battle, continued to serve me well. I took good care of it, changing the oil regularly and making sure it was properly maintained. In a weird way, I'd become attached to it. This machine had been the catalyst for standing up for myself and for positive change in the neighborhood. Every time I fired it up to clear my driveway after a snowstorm, I felt a little surge of satisfaction remembering how Patricia's attempt to weaponize it against me had backfired spectacularly. 2 years after the lawsuit concluded, I ran into Richard Donovan, the HOA's attorney, at a local restaurant. He was there with his family and I was picking up takeout. We made eye contact, and after a moment's hesitation, he came over. "Lucas Yates, right?" he asked, extending his hand. I shook it, curious about what he wanted to say. "That's me." "How are you, Richard? Doing well? Listen, I wanted to say that case was eye-opening for me. I'd handled a lot of routine HOA matters, usually helping with document filing and basic legal questions. But I'd never seen a board go so far off the rails. After Judge Reynolds issued her ruling, I actually started reviewing my other HOA clients more carefully to make sure they weren't overstepping their authority. Found a few situations that could have turned into similar problems and helped correct them before they escalated, Richard said, seeming genuinely sincere. "That's good to hear. I never thought Patricia would push things as far as she did," I replied. "She was something else." Completely convinced she was right even when the evidence clearly showed otherwise. "Some people just can't handle even a little bit of authority," Richard said, shaking his head. "Anyway, I just wanted to acknowledge that you were right to fight that case. It needed to happen." We chatted for a few more minutes before his food arrived, and we parted ways. It was an unexpected conversation, but it reinforced something I'd learned through this whole experience. Most people, even those on the opposite side of a dispute, recognized right from wrong when the facts were laid out clearly. Patricia had been an outlier, someone so convinced of her own righteousness that she couldn't see how badly she was abusing her position. As time went on, the whole incident became part of neighborhood lore. New residents would hear about it from long-time homeowners, usually as a cautionary tale about the importance of HOA accountability. The story got embellished slightly in the retelling, as stories do, but the core facts remained accurate. An HOA president tried to evict someone over a snowblower. The court ruled the HOA had no authority, and the HOA got fined instead. It was the kind of story that made people feel good because justice had prevailed. I stayed on the HOA board for 3 years before deciding I'd done my part, and it was time for fresh perspectives. By then, the culture had completely changed from Patricia's era. The board operated transparently, followed proper procedures, and treated homeowners with respect. Violation notices were rare and only issued for legitimate problems like safety hazards or clear bylaw violations. The neighborhood was thriving, with well-maintained common areas, active community engagement, and property values steadily increasing. On my last day as a board member, Tom presented me with a plaque at the annual HOA meeting. It read, "Lucas Yates, for courage and integrity in standing up for homeowner rights, with gratitude from Pinewood Heights." I was genuinely touched and kept the plaque in my home office next to my law degree from the University of Colorado and other meaningful items. Looking back on everything that happened, I wouldn't change how I handled it. Standing up to Patricia's bullying and illegal tactics was the right thing to do, not just for myself but for the entire community. The lawsuit wasn't about revenge or making Patricia suffer, though I admit there was some satisfaction in seeing her held accountable. It was about establishing boundaries and making clear that HOAs serve homeowners, not the other way around. The money I recovered in attorney fees got put back into home improvements. I renovated my kitchen, updated the bathrooms, and built a nice deck in the backyard. Every time I enjoyed those upgrades, I thought about how Patricia's overreach had inadvertently resulted in tangible benefits for me. The universe has a funny way of balancing things out. I also became something of a local resource for HOA questions. People would reach out asking about their rights, whether their HOA was overstepping, or how to challenge questionable enforcement actions. I wasn't an attorney and always referred people to Amanda or other qualified lawyers for actual legal advice, but I could share my experience and help people understand the basics of HOA law. Several homeowners successfully challenged their HOAs based on strategies similar to what Amanda had used in my case. The relationship between HOAs and homeowners is inherently tricky. HOAs serve a legitimate purpose in maintaining common areas and protecting property values through reasonable standards. But they also have the potential for abuse when board members let power go to their heads or pursue personal vendettas disguised as rule enforcement. My case illustrated both sides of that equation. The HOA under Tom's leadership was a positive force that enhanced the neighborhood. The HOA under Patricia's control was a nightmare that harassed residents and exceeded its legal authority. Colorado eventually passed additional legislation strengthening homeowner protections in HOA disputes, partially inspired by cases like mine. The new law required HOAs to provide detailed information about homeowner rights, established stricter standards for violation notices, and created an easier process for homeowners to challenge HOA actions. Amanda was actually involved in consulting on the legislation, using examples from my case to illustrate why stronger protections were needed. On the 5th anniversary of Judge Reynolds' ruling, the neighborhood threw a party. It wasn't officially about the lawsuit, just a general summer celebration, but people kept bringing it up. We'd grown closer as a community partially because of the shared experience of Patricia's tyranny and the relief when it ended. Neighbors who barely knew each other before had bonded over stories of ridiculous violation notices and celebrated together when the court ruled in my favor. "You know what the best part is?" Tom said that evening as we stood around the grill in the common area park. "We're not afraid of our HOA anymore. We know it works for us, not against us. That's how it should be everywhere." He was right. Fear shouldn't be part of the homeownership experience, certainly not fear of your own HOA. People work hard to buy homes, often spending decades paying mortgages and building equity. They deserve to enjoy their properties without constantly worrying about arbitrary enforcement actions or power-hungry board members making their lives miserable. My fight against Patricia's illegal eviction attempt was really about that larger principle. Homeowners have rights, and those rights matter. The Snowblower story, as it became known in the neighborhood, was ultimately a story about standing up to bullies, following proper legal processes, and holding people accountable when they abuse authority. It wasn't glamorous or particularly exciting in the day-to-day reality of court filings and attorney meetings, but it mattered. Sometimes standing up for yourself has ripple effects you never anticipate, creating positive change that extends far beyond your personal situation. I still live in the same house in Pinewood Heights. The HOA continues to function smoothly under rotating board leadership that takes its responsibilities seriously without taking itself too seriously. My snowblower sits in the garage, ready for the next winter storm. And Patricia Morrison is just an unpleasant memory, a cautionary tale about what happens when someone mistakes an HOA presidency for absolute authority over their neighbors' lives. Every time it snows and I fire up that snowblower to clear my driveway, I smile a little. This ordinary machine, doing the ordinary job of moving snow, once became the focal point of an extraordinary battle over rights and authority. It reminds me that sometimes the biggest fights start over the smallest things, but what matters is having the courage to stand your ground when you know you're right. The court agreed with me, ruled the HOA had no authority to evict me or even penalize me, and fined them $15,000 for their abuse of power. That's justice, and it feels as good now as it did the day Judge Reynolds brought down her gavel and declared that HOA overreach would not stand in her courtroom. The neighborhood is peaceful now, the way residential communities should be. People enjoy their homes, participate in community activities when they want to, and generally live their lives without interference. The HOA handles its legitimate responsibilities like maintaining common areas and organizing neighborhood events, but it doesn't intrude into people's daily lives with petty enforcement actions. That balance, that mutual respect between homeowners and their HOA, is what Patricia's defeat made possible. And it all started because I refused to accept an illegal eviction notice over a snowblower. Sometimes the little battles turn out to be the most important ones.